This morning, and today's Sunday, the 29th of November, 2020, I posted a video about a court case, we'd call it Kelly v. Wolf, in Pennsylvania, adjudicated by a state court judge, Patricia McCullough. Kelly et al. Had said basically that Act 77, which is a Pennsylvania statute governing elections, was unconstitutional because it was an amendment to the rules set out in the state constitution, and as such had not been passed as an amendment, but as a statute, and ergo was unconstitutional. All the mail-in ballots, not the absentee ballots, but mail-in ballots, which had been requested without meeting the necessity as outlined in the state constitution, would be thrown out. Judge McCullough had ruled that this case had merit and it should go forward. It was a big victory for Wolf and company and for the Trump administration. The Trump campaign, I should say. As I suggested in the video, it would probably be overruled by the Pennsylvania Supreme Court. And actually, before I was able to post the video this morning, it was. And that's what I want to talk about in this video, the Supreme Court of Pennsylvania decision to vacate her ruling. Now, as I said in that video, I expected that they would overrule her. The reason I said that was because they're already in on this. They had not only ruled that Act 77 was okay, they had expanded on it in an unconstitutional fashion on their own part. And this is being charged in several cases because under the federal constitution, state legislatures set up voting laws. And what the Supreme Court in Pennsylvania had done was to take Act 77 and expand it. Instead of getting the votes in by 8 o'clock, closing polls, it only had to be postmarked on election day, and you could count votes that came in as late as Friday. Now, that is nowhere to be found in the Constitution of the United States, in Act 77, or in the Constitution of the state of Pennsylvania. And the Supreme Court of Pennsylvania is not a legislative branch. So that was the problem. But my suspicion was, given the fact that they were already in on this, and I don't mean in terms of conspiracy, I mean in terms of betting, that there's so much in the pot, they might as well go all in at this point. Because to find virtue in McCullough's argument, and the argument that was made by Kelly and company, would be to make themselves look like fools. So they might as well just stick to their guns and go with this. So the fact that I woke up this morning and found out that they had already vacated the decision did not surprise me in the least. It was exactly what I expected, exactly what I predicted in the video that I had just posted this morning. What I was eager to see was their reasoning. What sort of gymnastics did they go through to get to the point where they could vacate her finding? I mean, after all, you just don't issue decisions. You have to issue a decision and explain your reason. And I wanted to see what reason or reasons they used to vacate her decision. So I found pretty easily the case in question. I downloaded it. Technically it's 3 pages, but the way it starts and the way it's laid out, it's really only 2 pages of text, which is surprising. I think her decision was 12 pages of reasoning, and they answer that with basically 2 pages of reasoning, which right away makes you think, this looks a little odd. What I really found surprising was the reasoning they used. There were a couple of things that I had seen various people on social media argue that why you could throw out or vacate her decision. But the Supreme Court of Pennsylvania didn't use any of those. They came up with 2 other ones, which are, in my view, remarkable. It says a lot about the lack of reasoning, the lack of legal savvy on the Supreme Court of the state of Pennsylvania. The first line of reasoning was it's going to cause hardship for the state. That they've already voted, they got all these votes in, what are they supposed to do? This will cause all kinds of turmoil, all kinds of problems. Now, that's undoubtedly true. And I had mentioned that in my own video. This is a big deal. But if you think about that for a second as legal reasoning by a Supreme Court. Imagine, let's take the Brown versus School Board decision, 1954, I think it was, which overturns separate but equal, which was set by Plessy versus Ferguson in 1896, I think it was. Maybe I'm off by a year, but I think it was 1896, Plessy versus Ferguson. The railroad case, which established separate but equal as a doctrine. Now, after the Plessy decision, states started passing all these statutes, putting into state law procedures and laws regarding segregation. That was, after Plessy. So say a state, Mississippi, had passed a law regarding segregation of something, some sort of public thing, schools, for example, and they passed it in 1898, a year or two after Plessy. What if the Supreme Court in 1954, the U.S. Supreme Court, re-litigating this question of separate but equal, of legalized segregation, had said to the appellants, well, we think you've got a good case here, but you know how much of a mess this is going to cause in all these different states? I mean, every state that has laws on the books for segregation, every school system in the South, and even some of those in the North, which have segregated processes, legal systems, you name it, sports, all these things are going to get struck down. It's going to cause all this turmoil, all this hardship. So, sorry, we're just going to let it stand. I mean, after all, it's been on the books now for, 60 years. I mean, what kind of legal reasoning would that be? Oh, it's going to cause hardship. I mean, if something is constitutional or unconstitutional, hardship doesn't have anything to do with it. I mean, if some law is found unconstitutional, well, it's going to cause problems. So, we'll just look the other way on it. That's basically the argument the Pennsylvania Supreme Court made on this. Remember, the argument made by Kelly et al. Is that Act 77 is unconstitutional. Judge McCullough found a rational argument there that should be heard by a higher court, a full court, instead of just a single judge. And here's the Supreme Court saying, the Supreme Court, nowhere in these 2 pages, maybe 3, depending how you want to count that, but basically 2 pages of text, does the Pennsylvania Supreme Court say that Act 77 is in fact constitutional. They don't even argue that. They don't even discuss that. They don't overturn, they don't vacate Judge McCullough's argument because she was wrong about the constitutionality of Act 77. They don't even address the issue. They just said to strike it down would cause problems. Well, anytime you strike down an unconstitutional law, it's going to cause problems. I mean, that goes with the territory. The other argument they make is a doctrine called Lash. But basically, Lash says that you have to, if you've got a complaint, you've got to bring it up quickly. If something happens and you want redress, you can't wait too long. Now, I actually was familiar with the term. I first saw it and I said, where have I heard that before? And it involved a case in 1991. My ex-wife and I, we bought a house. And we had a neighbor. We'll call him neighbor X. And if you're looking out to the street, he was on our left. And neighbor X had constructed, before we moved in, a fenced pen for a dog, which was on a concrete slab. And it was back in the wooded part of our lots. So usually you didn't even see it except in the winter when all the leaves would fall off the trees for the most part, except the pines, but they were tall, so you'd see the fence. We never thought anything of it. Nobody, when we bought the house, said, oh, it's on your side of a line, which it was. It was fine for years later. He and his wife broke up, and they were going to sell the house. The next thing I know, he's at my door, and he's telling me that he's been informed from the buyer who was buying his house and the buyer's realtors and lawyers and everything, that the corner of the slab, not the fenced area itself, but about an 8-inch triangle, because it was a rectangle and the angle, one of the angles was across our line. It was about an 8-inch sort of perfect rectangle was on our property. And did I have a problem with that? And I said, no, I could care less. I never go back there. You can't even get back there because of all the brush and everything. I said, I don't have a problem with that. And his lawyer was using the doctrine of lash, that thing had been built before we moved in, and neither we nor our realtor at the time we bought the house, nor the owner of the house before we bought it, had ever complained about the location of that dog pound on our property. And using this doctrine, there was nothing to worry about. Now, that's the way that thing's usually used in cases like that. Now, let me just add, it didn't fly. Because what we would have to do, it turned out, both he and I would have to get lawyers. We would have to redraw the boundaries, refile all the lot maps and all this other stuff. It was going to cost us, each of us, hundreds of dollars to get this thing adjudicated for the new owner to buy. So basically what he did, he got a sledgehammer, he went out and he broke off the corner of the slab, which didn't affect the fenced area at all. And that took care of it. But that's what this thing is usually used for. Cases like this. The Pennsylvania Supreme Court used that doctrine to adjudge the constitutionality of a state statute regarding elections. Now, I'm not a lawyer, I'm not a legal scholar, but just looking things up on the internet, I could not find a case. This is usually used. First off, it's never used, almost never used by the courts themselves. It's usually an appellate, like in this case, the state of Pennsylvania, would claim that it was too late to do anything. But for a Supreme Court to use this in a case not involving a dog pound or not involving, a petty crime that wasn't, nobody complained about or something for a year. On a question of the constitutionality of a voting law is, quite frankly, in my view, absurd. And it shows the depths to which that Supreme Court has sunk in terms of partisanship. I mean, it's like they're grasping for straws. As I said, I've had people argue with me on social media for the legality of Act 77 who make better arguments than the Supreme Court of the state of Pennsylvania. That's how bad an argument it is. I mean, to use this, and think of the principle involved here. Imagine using that principle in Roe v. Wade. Now, Roe v. Wade was 1972. There were the laws that they addressed in that, they said themselves in the court decision, involved state laws across the country that went back, some went back a century. I mean, the prohibition of abortion in the Hippocratic Oath goes back over 2,000 years. That's a long time. The particular law in Texas involved had been passed in 1961, which is over a decade before the Roe decision. Imagine if the Supreme Court in 1972 had said, well, the Texas law on abortion was passed 10 years ago, more than 10 years ago. You should have challenged it then. The fact that you didn't challenge it in 1962 or 1961 when it was first passed means you didn't do due diligence, and under the doctrine of lash, we're not going to overturn the Texas state law. This is legal reasoning from a state Supreme Court. That's what they said. That's their argument. Their argument is this law was passed in March 2019, and nobody said anything about it until after the election. It's been 1 year, a little over 1 year, about a year and a half since it was passed by the state legislature in Pennsylvania. And basically, the Supreme Court of Pennsylvania is arguing that you waited 1 year too long, and this unconstitutional law, ergo, is now constitutional simply because nobody said anything about it for a year. I mean, to use that reasoning to apply it for Roe v. Wade, well, the Texas law in 1961 is unconstitutional, but yeah, you should have said something then. It's 11 years now. It's too late. Or what about Brown versus the school board? Well, these segregation laws were passed in the 1890s or early 20th century. It's the 1950s now. You've waited too long to challenge them. Sorry, doctrine of Lash. Forget it. We're going to let these laws on segregation change. And besides that, you know how much disruption this is going to cause? It's going to cause all this hardship for all these people. So we're not going to touch that. I mean, this is absurd legal reasoning. You don't have to go to law school to know this is BS. I mean, this is absurd. And what's really absurd is that nowhere do they ever say this thing's constitutional. Act 77 is constitutional. They never make that claim. They are almost acknowledging that it's unconstitutional. But I guess their argument is if you pass an unconstitutional law and nobody challenges it for over 12 months, bingo, it's constitutional. If you read the processes you have to go through in Pennsylvania under the state constitution to amend the Constitution, it has to get passed by two different, congressional sessions. It's got to be approved. It's got to be signed twice by the governor. Then the text of the amendment has to go and be published in major newspapers across the state and circulated. And then it has to go onto the ballot where people can read it. I mean, the whole purpose of the amendment process as outlined in the Pennsylvania Constitution is to make sure you can't sneak stuff past the people. I mean, that's the whole point of making you go through this process so that people notice that you're changing the Constitution. But basically what the Supreme Court of Pennsylvania has told us, you don't need to do that. If you can slip something through and nobody notices and nobody says anything about it for over 12 months, bingo, you've amended the Constitution in a de facto sense. Again, this is the legal reasoning of the Pennsylvania Supreme Court. This is the best they could do. It makes no sense. It's inane. And I hope to hell this case goes forward and gets challenged in various district courts, possibly all the way to the Supreme Court. I hope it doesn't get that far. I mean, if somebody looks at the merits of the petitioners and the legal reasoning of the Pennsylvania Supreme Court using the doctrine of Lash and, disruption, nothing would ever get changed in this country. We would never, we'd still have segregation in this country. You change the Constitution, or you defend the Constitution and find things unconstitutional, you're going to disrupt the system. You're going to cause people discomfort. That's what it's all about. And I said a bunch of bad things about Pennsylvania, yesterday about what goes on the Supreme Court, what's going on with the governor, what's going on with the legislative branch. I mean, the legislative branch, remember, I have to say it, is controlled by Republicans. Republicans passed this law in March. Not the Democrats were involved too, but the Democrats don't control the legislative branch. Both houses are in Republican hands and were last year. And they passed it in 2019. This has nothing to do with COVID. This was March 2019, not March 2020. This is long before this push for mail-in ballots. So you look around and you look at both parties and the court system and the governorship and the whole state looks like it's, I don't know what they're doing up there. They don't seem to be making any sense. There's certainly no internal coherence to the operations of the state. Set aside questions of fraud or stealing elections. I mean, just rational arguments coming out of their court system, rational arguments coming out of the Pennsylvania Supreme Court. They seem incapable of being anything but partisan in how they've decided cases recently. I'll post a link to the decision below, unless that gets taken down like the other one did. I printed out a copy just in case. And let me know what you think. Let me know in a comment. Am I off a reservation here? Am I losing my mind? What the hell is going on? If you like the video, give it a thumbs up. Didn't, give it a thumbs down. That's fine too. Subscribe to the channel if you can. Share the video with your friends if you like. Hit the notification button so you know when I post new videos. And until the next time, keep fighting.